at sea about the maritime law readiness for unmanned ships. Ladies and gentlemen, thank you for the invitation. What you said, we move on seamlessly in a fluid way, so let's come on the board. We're going to navigate in the area of law. Is the maritime law ready for the unmanned ships? Perhaps autonomous ships? You can see my presentation. It uses illustrations that are often results of my cooperation with AI. This first picture is interpretation of AI of my title. AI was very explicit. There are no metaphors. It does not understand metaphors. So this creativity, I think, is questionable. Let's move on. First, let's put some order into the vocabulary. You're going to hear from me about autonomy and autonomous ships. Autonomy is much broader than just autonomous ship. In the maritime panel yesterday, we heard explanations. The International Maritime Organization, which is a regulator of the international maritime law and one of the UN agencies, differentiates four autonomous levels of autonomy. The first one is where we have the crew, but the autonomous processes support the crew. The second level is there's a crew, but the ship is navigated remotely. And for the purpose of this presentation, we're most interested in the third and fourth. The third is remote navigation, no crew, and fourth, and this is the place for autonomy. This is autonomous ship, entirely navigated by AI. In my presentation, I will cause MASS, MASS, Maritime Autonomous Surface Ships. I've participated in the international conference that coined this term, and it reads as Maritime Autonomous Surface Ships. I will try to tell you, emphasize that the ships that use autonomy, particularly the vessels of the third and fourth degree, entirely autonomous ships, are a huge challenge to maritime law. And maritime law has never had this challenge before. All the regulations, as you may think, all the regulations that are well rooted in the antique times, they were written about a ship that has a captain on board. So this revolution is now facing an area of law that is a very traditional one. In this maritime era, we have solutions that really reach antiquity, back in time. Maritime law, we might say, it's conservative. It's not prone to long changes, serious changes. There were moments when in the face of new threats, for example, the supertankers and the dangers related to them, in the second half of the 20th century, some courageous, bold decisions were taken, and for the first time there were regulations talking about the strict acute responsibility related on the risk provisions. So that's conservative law, but with some signaling that if it's needed, a change is possible.
I jeszcze jedna informacja na slajdzie tytułem wyjaśnienia. Ostatnia już taka wstępna.
One last preliminary remark. I said it before, but I want to emphasize it. We need to understand, ladies and gentlemen, that in terms of legal maritime regulations, the regulatory center moved from the national level to international level. Poland is a member of International Maritime Organization. We have a representative there at the IMO, and since it's international navigation of autonomous vehicles, then this regulation needs to have an international character, and that's what I will be talking about today.
Okej. I zaglądamy
Very well.
sobie,
And
na początku
let's
chciałam Państwa
see
zaprosić,
now the
do
following thing.
wnętrza, właśnie
We're going to have
tej
a
sali
look
plenarnej
into this plenary
IMO,
session of IMO, International
Organizacja Morska jest
Maritime
podzielona na kilka
Organization. It is
komitetów.
divided in
Prace
several
nad
committees,
statkami
and the ship
bezzałogowymi, nad tymi
autonomous
masami
ships, the
toczą się tak naprawdę
MAS,
przede wszystkim w trzech komitetach,
is
ale
the
o dwóch
work of
chciałam
three
Państwa
committees
opowiedzieć.
mostly, and I will tell you about two of them.
W Komitecie Bezpieczeństwa
That's the
Morskiego,
Maritime Security
który
Committee
pracuje obecnie
that works currently on
takim aktem, który się
an
nazywa
act.
Code, czyli
It's
kodeks
called
MAS.
MAS
Ten akt prawny
Code.
ma być przyjęty, takie są
This
plany,
legal act is
są
supposed to
przepisy
be adopted in
systemu, ma charakter
2026. It
wiążący,
will be
ma
not
mieć charakter
binding, but it will be
wiążący
obligatorily
po
binding after
2026. Co
2023.
znajduje się w tym kodeksie MAS?
No,
Znajdują się wymogi
2032.
operacyjne, jakie muszą
There are
będą musiały
operational
spełniać statki,
rules for the ships,
żeglugę
and
międzynarodową.
these rules have to
I
be
rzeczywiście
obeyed
ten kodeks MAS, on
for
przyjął taką bardzo ciekawą,
MASS
taki bardzo
to
ciekawy
be able to
sposób
navigate.
regulacji,
So the MAS
bo on nie
has
mówi,
an
jakie
interesting way
technologie
of
muszą być
regulating. It
przyjęte,
doesn't
on
say
mówi
what
o tym,
technologies have to
jakie
be adopted, but
funkcje
what
te technologie
functions
muszą spełniać.
technologies
A
need to
następnie
meet.
od
Afterwards, starting with functions, the public administrations or classification societies will then evaluate if a technology meets conditions or not. An evaluation model that I think is reasonable because it does not block the development of technology, it does not prefer some solutions to the others. It's called goal-based approach. So it will enable the MAS to have functional operational requirements included.
Kolejny komitet,
Next committee
w którym
in which
toczą się prace nad statkami,
the work on autonomous ships is held is a committee where I take part as a member of delegation of the Republic of Poland. That's the legal committee. The role of the legal committee is to adopt regulations in the aspect of the civil liability for events on sea or incidents. And the legal committee, just like the Maritime Safety Committee, what they did was to carry out regulatory scoping exercise, which is a sort of review of the existing regulations, international conventions that are, adopted under the aegis of these committees. Are they relevant to MAS, or would they have to be expanded or interpreted in a way that would broaden the interpretation, or they might be contradictory, inconsistent enough that they would have to be changed. So after this RSE exercise, what the committee did was they said, we're going to wait for the MAS code and we're going to see. We'll go back to working on the liability recompensation if an incident or accident takes place. A very important decision was made. Unfortunately, I think if it's not changed, it will be a problem in the legal regulations, and I will tell you more about that in a moment. Legal committee said, what we're going to do for the time being is to deal only with those conventions that were adopted under the aegis of the legal committee, and these conventions deal with, quite frankly, very particular cases of accidents at sea. Oil spills, bunker oil spills, responsibility for the passenger damage. They don't deal with a hardcore problem, which is the liability for collision, where MAS is included. Non-crew ship in a collision with anything else. For the time being, the legal committee says we're not going to deal with that. What does it mean? Let me tell you in a moment. Now, the MAS code. More or less, we know now where what is the direction of their work, and the shape of this code is more or less expected. We know it won't involve passenger ships. Now, in the international navigations, only the
bezzałogowe, tylko towarowe.
cargo non-cruise ships would be allowed. And we know that's a very important decision, that for every type of mass, even the one that is steered entirely by the AI, a human being will be required. That will be a captain, a mass master, person that will always have a possibility to technologically intervene, to pull out the plug, so to speak, in case of an accident or an event. I think we may talk about it later on. Will that not put a brake on the technological development? Since we say, okay, masses are safe enough to allow them for navigation, so do we need this person in the end of the chain to have the security provided, right? Does this person need to be able to pull the plug? Now, let's move on. What is now in the law is the guidelines. International Maritime Committee adopted the guidelines in 2019 about the mass testing. EU Operational Guidelines 2020 was adopted on the European level, and some countries, such as Belgium, Norway, and UK, adopted their own national regulations on the basis of IMO. So they have the regulations for autonomous ships testing. I will skip 2 slides, and I will go back in a moment. A little bit of national regulations. I think we are in a very important moment. I can see that in some of the countries, work on the mass regulations for national navigation, for the international navigation, we need international rules. But some countries are very far ahead. South Korea, Japan are very much interested in autonomous ships because they have problems with the, interest. People are not interested in being sailors then, and Japan has, islands, right? I searched through the law, and in Polish law there's one provision, the Article 3b and the Act of Law of Maritime Areas and Maritime Administration. It allows the director of the Maritime Office to close some area for the testing of the autonomous ships without a crew to be tested. I think it's quite unfortunate there are some levels of autonomy. If I was to, be very critical and literal about that provision, the testing of ships without crew could not be possible even if there's a remote control of a human being. So with my colleague from the Jagiellonian University, we compare in the Academy of Comparative Law. We sent out questionnaires to very many countries in the world. They will respond about how their national regulations are ready for autonomous ships. So I will tell you next year about the results of that survey. Not there yet. Sorry, I want to go back. I wanted to make my presentation more attractive and so show you my pictures. That's not AI. I went to the Maritime Law Congress to Tokyo, and the Tokyo University invited the lawyers. We deal with masses, so we had a trip in the first level autonomous ship. The ship was full of crew and there was a captain, but after this switch was switched, the one that I marked here with an exclamation mark, the ship went into autonomous mode, so it gave the captains suggestions about what decisions to make to navigate. The captain could implement it or not. So we tried to avoid collision with another vessel sent by the university, and it was a success.
problematyczne z mojego
What seems to be the problem from my point of view
regulacji statków autonomicznych?
when we want to regulate the masses?
Kwestie
Definitely
odszkodowawczej
the liability and compensation, particularly for collisions. The current legal regulations that we have now are based on the so-called guilt principle. What does it mean? That person who incurred damage needs to prove that the other part was guilty, that the other ship was guilty, and that's the condition to receive compensation. In the era of autonomous ships, it will be a very big problem. We have been talking about this in the industry of advanced technologies, that there are difficulties with interpreting, explainable IE. XIE is explainable IE. We will definitely need opinions of experts, court experts, and the number of court experts in this area will be limited, costly court cases. Plus, these provisions, the explanations might be provided in a vague way because that's a business information, that's the sensitive information covered with non-disclosure agreements. It may lead to unfair consequences. Is that not an area that should be particularly changed? I can see that I'm running out of time here, so perhaps let me go to the next thing. Who is to blame, right? Who should be bearing the responsibility? The ship owner, mass producers, producers of operational systems. We definitely want to look for somebody who will take the burden of responsibility in maritime relations, is somebody who has an adequate insurance. So someone who might get insured, and I think the best person would be the ship owner. But this needs to be further discussed. And I have a slide about conclusions, but since I don't have any more time, I will just leave it like that. Just as a word of conclusion, just a couple of ideas that I really want to draw attention to. In maritime law and in the industries that are represented by my colleagues, when we work on legal regulations, we really need to work tightly, we as lawyers and representatives of the technology, the engineers. When we create the legal regulations, we need to know the risks. So the dialogue is of crucial importance. And I'm really looking forward to having such meetings because they enable us to really have the cooperation and the dialogue. They make it possible. And with this optimistic note, I will end and hand the floor over to the next speaker.